how does a defense attorney negotiate with the prosecutor? Most people have no idea how that works. There's a couple different versions of how a defense attorney negotiates with the prosecutor, and I'm going to cover those in this video. So if you're interested in this area of the law, stay tuned. This is the video for you. My name is Lance Fryrear. I'm a defense attorney in Linwood, Washington. I've been defending people charged with crimes all throughout Washington State for more than 20 years, and I'm putting out these videos to help educate the public. So if you find this useful, please like and please subscribe. More people get to see it. More people get the help they need. Now I'm just going to jump right into it. How do us defense attorneys negotiate with prosecutors? And there's going to be several different ways that happens, and it may vary, of course, by the style of whatever particular defense attorney that you've hired. I think the main way that, way one, I'm going to say, that we will negotiate with the prosecutor is it's sort of a process over time. You originally talk to a prosecutor about, hey, what's your initial position in this case, right? Because you don't want to start out too high, like, hey, I think my client did something like this, when the prosecutor thinks maybe it's less serious, right? We don't know, because each prosecutor has their own life experiences where they have different judgment values about what's really bad or what's not really bad. An example, I started the first 7 years of my career as a prosecutor. For some reason, I didn't really like taggers, right? If you made graffiti on somebody's fence or you tagged all this public property, that made me more mad than it made some other prosecutors. And so each prosecutor has their own idea of what sort of they want to respond to more. Now, if you came to me with a $5 candy bars, set of candy bars you stole, well, I might be less mad about that. And so it's generally good for the defense attorney first to get an idea of where the prosecutor's head is on a case, so we know where the starting line is. It'd be like if you're buying a house, right? You ask what the selling price is. You don't make an offer way above that when they want less than that. So it's sort of over time, we want to see where the prosecutor is and also learn what we can do to sort of push them towards a direction that's more favorable for the client. So that's the second way then I think we do things, besides just being over time, is having our client do some affirmative things so we're in a better position to negotiate with the prosecutor, right? When a prosecutor offers to dismiss a case or let someone go, it's not necessarily because they didn't think something happened, right? It's not because they make a determination, usually it's not, that the client's innocent. It's because, hey, it's my job to do justice as a prosecutor, and justice doesn't always require a conviction, and I may have too big of a caseload to try to convict everybody, so I have to make some judgment calls about where the resources of the government are going to be put to go after someone fully and to try to really crush them and punish them versus try to respond to the case in some other way. And so if your prosecutor really is impressed with domestic violence treatment, DVMRT treatment, well, we're likely, as part of negotiation, going to have our client do DVMRT treatment so we can say, look, we've had our client do something that will really make a difference for them, and they're not likely to be here again. So they're a better risk to give some type of offer that ends with a dismissal. So I would call this second way of negotiating with prosecuting sort of therapeutic negotiation, is what I'm going to call that, where we are saying, look at all the good stuff my client has done. Let's not look too closely at the details of the fact pattern in the police report, because, of course, the police are going to write a fact pattern in a way that justifies the charging of the defendant. They're not going to typically write good things for the defendant. So I'd say that's a therapeutic negotiation. I think the third level of negotiating a case would be more on a legal basis, right? Hey, you have a bad stop here. This officer claimed that the driver was swerving, but the video we got from the State Patrol doesn't show swerving, right? And are we going to use that legal problem to try to negotiate a reduction? Do we think that the legal problem was so strong that a judge would have the courage to dismiss a case? Very few judges have the courage to dismiss a case against a DUI driver, in my opinion. Also, the law is written in a way that is, for probably good reason, very against people in that situation. But from the legal perspective of negotiating, one of the downsides of it, it provides more risk for the client, right? Because the government has all this power. And if we give up this therapeutic negotiation and go straight to legal negotiation, we're encouraging the government to really look at their case closer, to get the facts that are on their side even more well established in the prosecutor's head. And it generally provides so much more risk for the client. It's hopefully either a combination approach with therapeutic or a secondary approach, because the prosecutor, if they're experienced, they know the law's on their side, right? They don't need to worry about it. They got a professional witness who's going to get on the stand and say what they need to say to take that very, very low standard to overcome a motion to dismiss or something like that. So when we have a potential client call up, I want an aggressive attorney, if we're really busy, we'll just hang that one up eventually, right? Because, or hopefully we'll just re-educate them about there's a difference between aggressive and effective. Aggressiveness can be part of being an effective attorney, but it's, in my opinion, is lazy attorney work, right? It's so much easier for the attorney just to be a technician and say, well, the light was red or the light was green or this person didn't see that, and let the jury decide. But that just carries all the burden on the client for risk, none of the burden on the attorney for being morally and emotionally responsible to try to get a result that is fair, regardless of what the fact pattern would say if we got to a jury trial, okay? Next, after legal negotiation, I'm finally going to call it something like legal. I'm going to call it litigation or trial work. I think that's the final level of negotiating with the prosecutor. Well, Lance, to go to trial, that's not negotiating, you're going to trial. Well, not really. Getting prepared for a trial and setting a case for trial will now make the prosecutor, just like it makes us, look at the case differently, right? They now actually have to talk to their witnesses. Are they a good witness or are they a bad witness? We know what it says on paper, but what do they sound like, right? We've had cases where the prosecutor would not move off of felony assault. We got to 2 weeks of trial. We did the victim interview, and as soon as the victim interview was done, the prosecutor's like, disorderly conduct, misdemeanor, deferred sentence, dismissed it in a year, goodbye. Still said the same stuff in the police report, but finally, nothing else worked. We finally got to the trial, the litigation trial stage, and now the prosecutor was forced to talk to their witness, and their witness was terrible for them. They sounded nuts, okay? So why didn't we go straight to that? Because we didn't know what they would sound like. We don't get a chance to talk to them until that last, little bit if it's their primary victim, right? They'll usually ask for prosecutor's presence during an interview. So that's why this is sort of a graduated approach, at least how many attorneys might do negotiation work with prosecutors. Additionally, once you set that case for trial, if it gets to there, now the prosecutor has some hard decisions to make. If there's 6 or 7 cases set for trial and there's only one trial judge available and they're running up against speedy trial problems, they're going to have to make some hard decisions about to change their position, possibly to offer more favorable results. Plus, at lower court levels and non-felony levels, it's a burden, right, for a prosecutor to get ready for a trial. They may not happen that much. Their whole weekend might be blown, right? There's lots of things that can affect how hard someone wants to hold the line from a prosecutor's perspective when they actually have to put in the work themselves. And until you confirm that second for trial and they're going through cop interviews and witness interviews, they don't really have to put in the work. It's not real. And so again, why don't we start with that? Because it's higher risk for the client typically, because usually they will often have good witnesses and they will definitely be able to rely on a jury who typically doesn't like people charged with crimes. And so all the advantages weigh to them. And if you lose a jury trial, while it would be said in public, well, you don't get a worse result after losing a trial than entering a deal. That's simply not true. So those are the ways that defense attorneys negotiate with prosecutors. There's probably a lot of other ways. Those are the ones that came to my mind here as I'm making this video on the fly. And, I think it's important to realize that if your attorney's taking a while to try to resolve the case, it's because they're trying to get you the best result with as little risk as possible for you. It's our job to understand the risk and how it really works, not how you wish it worked, how we wish the truth mattered, how we wish the government cared, how we wish all those things. The decisions about cases are down to the individual prosecutor, the individual client who decides what to do, and the individual judge. It is case by case, court by court, person by person. So if your attorney's taking a while, give them a chance because they're working hard to try to save you. So hope you found that useful. If so, please like and please subscribe. More people get to see it. More people get the help they need. And more importantly, if you have a criminal problem in Washington State, feel free to reach out to my firm. We get on board. We'll listen to what happened. We'll identify a way forward, and we will be there for you. Thank you.